Welcome, everyone. Thank you so much for joining us for this arbitrate.com event. We are very, very excited about the expert panel we have pulled together today to discuss recent SCOTUS jurisprudence around arbitration. We have a lot of meaty topics to dive into, and we have the best minds in the country to do so. So let me just provide a brief introduction of everybody, and then I'll hand it over to Amy to facilitate things. I will say also, we love chat messages. So if you have any questions or thoughts or comments, please don't hesitate. I'm actually click the magic mute all button in a second, and then I'll ask my presenters to unmute. But if you have any comments or questions or anything, please don't hesitate to put them into the chat. Sometimes we chew items over a little bit there, but when we do open it up for participants to ask questions, we will surface the comments that were made in the chat. So let me start out by welcoming Professor Imre Szalai, who is the Judge John D. Wessel Distinguished Professor of Social Justice at Loyola University's New Orleans College of Law. Wonderful to have you here, Imre. We also have Sarah Rudolph Cole, who many of you know, the Michael E. Moritz Chair in Alternative Dispute Resolution at the Ohio State University Moritz School of Law. And we have my good friend, Angela Downs, who actually I was just mentioning before the call. We went to high school together, so this is lovely to reconvene with you, Angela. But Angela is Professor of Practice at the University of North Texas Dallas School of Law. And we also have my good friend as our facilitator today, Professor Amy Schmitz, who is Professor of Law at the Ohio State University Moritz College of Law, who will serve as our facilitator. So with that, let me hand it over to you, Amy, to kick us off.
Okay, well, thanks everybody. And for those who watch it on the recording, thank you as well, because I do think being in August, there will be quite a few that will be listening and watching on the video recording. I'm super excited. I felt like we were assembling the Avengers for this very special event to discuss the US Supreme Court decisions on arbitration that were decided in this past term. There were some big ones and some really important cases. So we're going to get right to it. We're going to have different commenters on each case, and then afterwards we're going to bring it together with some questions. So Imre, if you want to start us off on Badgerow.
Sure. Thanks, Amy. Thanks, Colin, for arranging this and for inviting me. Let me just share my screen real quick. I have some slides regarding these cases. So regarding Badgerow, the FAA, of course, the Federal Arbitration Act, it helps facilitate arbitration through some minimal judicial involvement. And I think it's helpful to think of the FAA as involving three different stages. There can be front-end matters, which involve really the compelling of arbitration, where one party refuses to honor an agreement to arbitrate, and a court's asked to compel arbitration. And there are also what I call middle proceedings. Once an arbitration is commenced, a witness may ignore an arbitrator's subpoena, and the FAA authorizes courts to assist in the enforcement of that subpoena. And also, courts can get involved in appointing arbitrators if one just doesn't work out for some reason. I had a situation where a co-arbitrator passed away in the middle of a proceeding. I'm not in the actual proceeding itself, but while it was pending, and so not during the hearing itself, but if there's a disagreement regarding the appointment of an arbitrator, I consider that a middle proceeding. And also in the back end, of course, there could be requests for a court to confirm or vacate an award. And at the same time, it's important to remember that the powers of our federal courts are not limitless. They're inherently courts of limited jurisdiction. So even though the FAA authorizes courts to take certain actions, if you want to go to federal court, you have to separately satisfy the federal court's requirements for subject matter jurisdiction. And remember that there are two different types of subject matter jurisdiction in federal courts. There's federal question or diversity, where the right to sue is based on a federal statute or federal law, or where the parties are citizens of different states and more than 75,000 is at stake. So in Badgerow, the court was faced with the following question: when does a federal court have subject matter jurisdiction or power to enforce the FAA, really from the back end, when a court's asked to either confirm an arbitral award or vacate an arbitral award? And at the front end, we have an answer already. This is going back to 2009 from the Viking decision and looking at Section 4 of the FAA. If you look at Section 4 of the FAA, if you set aside the actual agreement to arbitrate, and you examine the underlying controversy between the parties to be arbitrated. And this is sometimes known as the look-through approach. Let's look through the FAA proceeding and examine the underlying controversy that will be arbitrated. If a federal court has power regarding that underlying dispute, to hear that underlying dispute, the federal court also has power to compel arbitration from the front end. And so if you have a consumer complaint, a consumer dispute against a company for a federal antitrust claim, or if you have a worker suing an employer for a federal Title VII claim, these two claims automatically trigger federal question jurisdiction in the federal courts. And so because there's power when you look at the underlying dispute, because a federal court would have such a power to hear the underlying dispute, the federal court also has power at the front end to compel arbitration if someone refuses to honor an arbitration agreement. Or if a plaintiff is from Florida and a defendant is from California, and there's a breach of contract dispute between them for more than $75,000, that dispute triggers federal subject matter jurisdiction. And because a federal court has power over that underlying dispute with this look-through approach, a federal court also has power to enforce an arbitration agreement. And this is the look-through approach. And this look-through approach, in my mind, it suggests the FAA is a procedural statute. You know, the FAA is designed and targeted really to solve that underlying claim. And if the FAA were substantive law instead of procedural law, the FAA would have and give rise to its own federal question jurisdiction automatically on its own, but it doesn't. And so I believe that the look-through approach from Baden, from this older case, it shows the procedural nature of the FAA. And if you turn to Badgerow and switch to the back end, the question in Badgerow is whether this look-through approach also applied to back-end FAA proceedings. For example, where a party is trying to confirm an award or vacate an arbitral award. And in Badgerow, the underlying claim was a federal employment law claim, which normally would give rise to federal question jurisdiction in the federal courts. And so if we applied a look-through approach to the facts of Badgerow, we would say a federal court has power regarding that underlying employment dispute. So the federal court also has power to hear an arbitral award, to confirm or vacate such an award regarding that federal employment law claim. That would be applying the look-through approach to the back end. But the Supreme Court this past term in Badgerow rejects the look-through approach for back-end proceedings. And the court mainly used a textual argument, reasoning that the language that you see in Section 4 that was at issue in Baden simply does not appear elsewhere in the statute. And so it doesn't appear that that look-through language that you see in Section 4 does not apply in Sections 9 or 10 of the FAA, which deal with confirming or vacating an award. And what's interesting is that the court in Badgerow, it conceptualizes an award not as a resolution of an underlying dispute. So if you have an arbitral award involving a Title VII claim, the court in Badgerow is envisioning it as a contractual right, as a bundle of contractual rights, perhaps that arises from the arbitration agreement itself. And contract rights just don't give rise to federal question jurisdiction. So for front-end proceedings, we have the Baden case. We apply the look-through approach, but for back-end proceedings after Badgerow, and presumably also for middle proceedings, federal courts can no longer use the look-through approach. They cannot rely on the underlying nature, the underlying claim, in order to analyze jurisdiction. Federal courts instead, at the back end and presumably for the middle proceedings, would have to rely on diversity jurisdiction to see if there's jurisdiction to either vacate an award or confirm an award. And so when the dispute is reduced to an award, the award is now treated as a contractual right, and we lose that underlying, say, Title VII or federal nature of the underlying claim. So after Badgerow, what happens if a federal court lacks power to hear an application to confirm or vacate an award? Parties will now have to go to state court instead. And I have several criticisms of Badgerow. There's an awkward result that I see here. And so I think it's a strange result. I love stranger things, but federal courts from the front end, they can look through to the underlying dispute when they're compelling arbitration, say, of a Title VII federal workplace claim. But at the back end, that same federal court, if it already closed the original case or there's no pending case, from the back end, that same federal court cannot confirm or vacate an award involving that same federal Title VII claim at the back end. And so I see a lopsidedness here created by Badgerow and Baden. And in my view, Badgerow seems to undermine the FAA's broad framework supporting arbitration. I would have preferred applying the look-through approach to all types of FAA proceedings. And so I'm a big fan of Justice Breyer's dissent, where I would take that directive from Section 4 and apply it consistently throughout all FAA proceedings. And the majority of justices, they're now applying what I call a piercing textualism when they're analyzing a statute. And I'm still researching this, but I think a strong textualist approach that exists today just didn't exist back in the 1920s. There was a weak form of textualism that began to appear around the New Deal. But in other words, when Congress passed the FAA, they probably never expected their words to be construed in such an extreme textual manner. And so something else I wanted to point out is that if you look at the legislative history, the FAA's main drafter, Julius Cohen, this was in a joint hearing in 1924, he submits a written brief explaining the FAA. He was the main drafter, and this written brief made it into the record. And he explains that a look-through approach applies to the enforcement of an arbitration agreement. And so think about this. He explains that a look-through approach applies whenever you're trying to enforce the FAA. And when he describes what is meant by enforcement, he discusses both the front end, like compelling arbitration, as well as middle proceedings. In other words, the look-through approach was not limited in the drafter's mind just to Section 4. And so there's an interesting legislative history. It's brought up in the Breyer dissent. I actually submitted an amicus brief in this case, and I brought up this legislative history in that brief. And so I think that all types of FAA proceedings are designed to help implement and enforce an arbitration agreement, whether you're talking about the middle, the back end, or the front end. And I think that the original drafters envisioned the look-through approach for all types of proceedings. And I just wanted to point out, there's a problem. With Badgerow, the court is taking a very nearsighted view, a limited view of arbitration as involving solely a contractual right. And I prefer the deeper view, like looking at arbitration as a procedural law or procedural mechanism to help solve an underlying dispute. Like, I don't, if a court now in the future will be asked to examine, does it have power? Does the federal court have power to say appoint an arbitrator or enforce a subpoena? I don't think the real dispute is about the subpoena or about appointing an arbitrator. It's about always the underlying dispute. And so I consider this particular decision very nearsighted. I think it was wrongly decided. I think statistically, petitions to confirm and vacate awards were always historically in the majority filed in state court. And so federal courts, just to begin with, even before Badgerow, played a minimal role in confirming or vacating awards. I think as a statistical matter, most petitions were filed in state court. And so state courts will continue to play a large role, but it'll be more difficult, though, if you want to access federal court now after Badgerow. And I think my 10 minutes are up, but I have other things to say about Badgerow if we can come back to it later on.
Thank you, Imre, very much. Great insights. And yeah, certainly an interesting sort of textualism, which we'll talk about at the end, kind of summing up where the court is going. So thank you for that. We're next going to talk about Morgan v. Sundance. We're going to have Angela start us off, and Sarah will also join in with her thoughts. So Angela, if you want to take it away.
I will. Thank you so much, Amy. And Colin, thank you so much for the invitation to speak on the panel. And it's always nice to see old friends. So let's talk a little bit about Morgan. Morgan is the second arbitration opinion of the term. And I think something that we do need to just spend a minute reflecting on is the extraordinary number of arbitration cases that the Supreme Court actually heard this term. It's almost unheard of. But Morgan was the second case that was heard. It was authored by Justice Kagan, and it invokes a plain reading of the FAA. It backs the plaintiff's position for the case. So let's talk a little bit about the facts of Morgan. So Morgan involves a Fair Labor Standards Act. The petitioner, Robin Morgan, sued Sundance, and Sundance was a company that it's a franchisee of Taco Bell's, and they own over 150 Taco Bell franchises throughout the United States, including the Iowa franchise where Robin Morgan was an hourly employee. The issue was that Robin Morgan felt as though she and other hourly employees were not being paid correctly for the work that they were doing for the Taco Bell. The case actually went to the Michigan Eastern District Court. And at some point, the case went to joint mediation. It was enjoined with another case, the Wood case. The mediation actually was able to settle that Wood case, but the Sundance case was not settled. It was then that Sundance actually moved to compel individual arbitration, and that's where our issue actually lies with this case. Morgan claims that in May of 2019, there was an arbitration provision in her contract, and we know that in most employment contracts there is an arbitration clause. But what the issue is that Morgan raises in this case is that Sundance has waived its right to compel arbitration by engaging in litigation. And so that's really the crux of what we're looking at in this case. And to me, it seems as though this case is really giving the little guy ammunition, because generally those arbitration clauses are so ironclad that it becomes very, very difficult for you to get around them in the from the sphere of being an employee. But in Sundance, we have Justice Kagan, who writes and really focuses on the issue of whether or not Sundance knowingly relinquished the right to arbitrate by acting inconsistently with that right. And she's really looking at what happened in the Court of Appeals and saying that the Court of Appeals may resolve the question, but the sole holding is that it may not make up any new procedural rule based on the FAA's policy favoring arbitration. So we know that the FAA favors arbitration and that they're pushing you toward arbitration. But really, this is, as I've said, this is a way for the little guy to actually have a little bit of firepower as they move through with these employment clauses, because so often than not, when there's an arbitration clause that's embedded into those employment agreements, there's no way to get around them. But this decision actually resolves that 9-2 circuit split. There were 9 jurisdictions that require a party resisting arbitration under waiver to prove that they have been prejudiced, while 2 jurisdictions do not have such requirements. Now, the opinion that came out in Morgan v. Sundance sides with that minority position. It rejects the idea that the FAA authorizes federal courts to invent arbitration-specific procedural rules. And it actually holds that the federal policy is about treating arbitration contracts like all others, not about fostering arbitration. I think that's really key because it's really, it's a message from the court that they are not trying to push arbitration, but really saying that they want to look at treating arbitration like a contract, and not just saying that just because there's an arbitration contract that's found within an employment agreement that it must stand, but really ensuring that that arbitration clause does not include any kind of prejudicial elements that could be found. But it's really key that they really are basing their opinion on the minority opinion and really looking outside the box. So as I said, I really think that it was a way for Justice Kagan to really highlight the importance of arbitration, the importance of looking at prejudice, and ensuring that those that are considered the little guys actually do have some power as they look at those employment arbitration agreements. So I feel like I've just been talking, but Amy, I know Sarah, you wanted to weigh in as well.
Yeah, Angela, I really like your your positive outlook on the case, that it's empowering the little guy, which, that's one of the things that the Supreme Court's been heavily criticized about, that the little guy doesn't get much power once the little guy is signed or agreed to arbitrate. And I guess I look at this as consistent in my mind with the way the Supreme Court has always treated arbitration. I think it was sort of saying to the appellate courts, look, when we say there's a healthy federal policy or a national policy favoring arbitration, we never mean that it's supposed to be treated better than other agreements. Is just a contract, and we want to enforce it. And the Supreme Court often refers to the hostility towards arbitration that existed prior to the passage of the Federal Arbitration Act. And so a lot of times I think that the notion is their lower courts will say, gee, we have to really bend over backwards to enforce these arbitration agreements. And so we should make it really hard for someone to waive the arbitration agreement just by participating in different procedures. We have to show that, unlike other types of plaintiffs, that the plaintiff's been prejudiced by typically the defendant's participation in arbitration. And the Supreme Court's just saying, no, it's just like any other waiver provision. We will treat it just the same. But a couple things I thought were interesting about this case. One concern I have is, and I've seen some analysis of it from various sources, that frequently parties are encouraged very strongly, sometimes in maybe mandatory language, to participate in mediation when they get to federal court. And one concern about this that's been raised by law firms writing about this case is, gee, should we participate in these mediation exercises when we have an arbitration agreement? Will it look like we have waived our right to participate, to enforce our arbitration agreement if we go ahead and participate in the mediation? Because of course the mediation is going to take some time, and that's time that's passing, which may look like the defendant doesn't want to enforce their arbitration agreement. So I'm a little worried about how that's going to impact it. One presumes that a court would not hold it against the defendant who's basically sort of being coerced into mediation, that they participated, but that's a little worrisome with this rule. And I do think it makes sense. I have a case now in arbitration that I think has been about 3 or 4 years in court before it went to arbitration. And to the extent that arbitration is intended to preserve resources, the notion that you should be participating in lengthy discovery and all those sorts of things in court, and then say, oh, but wait a minute, I have this arbitration agreement I now want to enforce, I think is inefficient and bad in that respect as well. So that worries me. I had a call with Bloomberg about a case that's now in the Ninth Circuit involving Michael's, the craft store, and their arbitration agreement. And they waited 10 months to enforce it, but there was only minimal discovery and no substantive motions were filed. But the district court judge said that was not considered waiver, but now we'll have to revisit it in light of Sundance. And so I guess the question is it just a time factor, or is it what the defendant did during that time period? And the Bloomberg reporter told me that there's been 14 rulings since Sundance, motions to compel arbitration or stay litigation, and they've been granted 6 times and denied 5 times. So he said, what do you think of that? And I said, I don't know. I'd have to see what the different defendants did in those cases that might justify holding that they waived their right to pursue arbitration. But I do think law firms are going to advise their clients, if you've got an arbitration agreement, put it in if you're filing a motion to dismiss or you're filing an answer, I guess it'd be a motion to dismiss probably if you're trying to avoid submitting to the jurisdiction of the court, and say, I've got an arbitration agreement that I want to have enforced, rather than waiting and trying to get that later. So those are just some thoughts about Morgan. I didn't realize how many cases involve this issue. I mean, I thought it was startling that there have been 11 cases.
I think the issue is more common than we had been thinking about, and I think that's why there were the sheer number of cases. Sarah, I want to pick up on just one. I want to pull out a thread that you mentioned with respect to cases going to arbitration before they go, cases going to mediation before they go to arbitration. I think that is such a common practice for cases that are going to court. We're even seeing it not only in our federal courts, but in just our state district courts and below, where judges are ordering cases to go to mediation just to see if there can be a resolution, because they're seeing it as something that the courts can use to perhaps have the cases get resolved, to take cases off the docket and have more, in a more efficient process for the parties. So I don't think that's necessarily going to go away. But I think, as you said, Sarah, that folks are really going to be looking at that more closely. And they are going to be looking at those arbitration contracts. I think under this case, Morgan, the Sundance, looking at them more as from a contract standpoint. So I think that's really going to change how companies look at these matters. I think it's going to be really change the tide.
Yeah, well, and we're going to move to the next case, but yeah, there's some really interesting nuances. I will say, when I was in private practice before teaching, we actually had quite a few waiver cases. It definitely came up for us quite often. So in other words,
Imre had a comment he wanted to make before we move on. Do you want to put that in there, Imre?
Sure, just real quickly, I completely agree with Colin that this decision seems like it's a step back from the aggressive views of the Supreme Court in the past few decades. Just one quick example, think about the Moses Cone presumption. If there's a doubt about the scope of an arbitration clause, we say that the issues are arbitrable. And that comes from nowhere from the FAA. And there's one sentence at the very end of Sundance, I was going to quote it, says, courts cannot make up new procedural rules based on the FAA's policy favoring arbitration. That hits me hard. If we took that literally and applied that principle to the last few decades of arbitration law, I think a lot of arbitration rules that we know would collapse. And so I completely agree with Colin that this case does feel like a step back.
Thank you. Great thoughts. Really interesting. And we'll circle back at the end. So the next case we do want to talk about is the Southwest Airlines v. Saxon case that just came out June 6th of 2022. Another unanimous ruling. And Sarah, take it away, please.
Thanks a lot. And some of you know that Justice Barrett was involved in this case at the Seventh Circuit level, and so wasn't participating, but it was otherwise unanimous. And interestingly, Angela, I don't know if you thought this too, but so they had Kagan writing Morgan versus Sundance, and then they have Clarence Thomas writing Saxon. And sometimes I wonder whether these narrowly written arbitration decisions, they want to mix up who writes it to show that there is unanimity sometimes in the court. Not every decision is a 5-4. Barn burner. And obviously they had a lot of incredible barn burners. I guess incredible, I don't know if that's the right adjective, but we'll leave that for somebody else to discuss. But I thought it was interesting, particularly because Thomas is often the dissenter in arbitration cases and wasn't in this situation, in part because this didn't really involve the sort of state law issues that he often, he doesn't believe the FAA should apply in the state court or state law issue cases. So this is a little different. I was not surprised by this decision, and I don't know if I could say I was surprised by any of the decisions, but of course now I'm doing it as a Monday morning quarterback. But I've sometimes thought it would be fun if there could be like gambling on arbitration decisions, because I feel like I would do pretty well on that, at least, although I'll put Hall Street aside on that. I was completely wrong about that case. But anyway, just getting to the facts of this case, it was a ramp supervisor for Southwest, Latrice Saxon, and her goal, like in many of these cases, was to file a class action lawsuit where she had alleged unpaid overtime on behalf of herself and other ramp supervisors. And she was claiming that she would fit within the exemption to the FAA for transportation workers. And those of you who are intimately familiar with Section 2 of the FAA know that it says that contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce are not bound by the Federal Arbitration Act. And I know Imre and I have agree on this, that this was not that this provision was, at least historically, intended to, in our view, I think I'll let Imre speak for himself, but certainly in my view was intended to exclude all employees from the scope of the Federal Arbitration Act. But unfortunately, the Supreme Court has interpreted it very narrowly, and basically said it's transportation workers, that when the Supreme Court said, or when the Congress said any other class of workers engaged in foreign or interstate commerce, that has to be interpreted in light of the words that come before it. And since the words that come before it are railroad employees and seamen, the idea is it's a very narrow exception, not a broad exception. But if you look at the legislative history of the Federal Arbitration Act, you'll find difference of opinion by those who drafted it. But it's kind of water under the bridge there. And the transportation worker exemption, though, has gotten some life, really because of our gig workers, the Uber and Lyft drivers, I guess ramp supervisors and other workers involved in interstate commerce who want to file class actions either under the FLSA or other kinds of wage and hour provisions. And they can only file those class actions if they can get into court. Because if you've signed an individual arbitration agreement, you have to go to arbitration as an individual. And so the question is a ramp supervisor a transportation worker who is exempt from the scope of the Federal Arbitration Act? And the court said, yes, that's right. She does supervise people who load and unload suitcases and other goods, but she also does that herself. And as a result, she's directly involved in activities that are in interstate commerce. The hard part about this case is it's very narrow, and again, it's quite textual. I think, and Amy's going to talk to us later about it's textualism, but not originalism, because if you were going to look at the statute itself, I think you'd probably conclude, I would have concluded that it excluded employees from the coverage of the act generally. But instead, now that we say that's not what it means, if you look at the text, I can certainly see how the Supreme Court came out this way. They looked at dictionaries of the time to figure out what the ordinary, contemporary, common meaning of that text was. And they used two different statutory interpretive canons, the meaningful variation canon and adjustum generis, which I was pronouncing correctly. But basically, the meaningful variation canons says, look, if you use a word that's different than a word that's used in a different statute, it must mean something different. And here, instead of using affecting or involving commerce, Congress used the word engaging and concluded that engaging in commerce is a narrower word than affecting or involving. I don't know. I guess that's probably right, but leave it to you. Engaging being narrower than involving or affecting. I think the other argument is a stronger one, the justum generis canon, which they've used more frequently and have used with respect to this exemption before, which is to say if there's a catch-all category at the end of a provision, but the words prior to that provision are narrow, the catch-all provision should be interpreted narrowly. And that goes back to seamen and railroad employees are clearly employees who are engaged in interstate commerce directly. And so the other transportation workers engaged in interstate commerce language should be interpreted very narrowly. The result being, because she loads and unloads cargo, which means she's having a direct involvement in interstate commerce, she should not be covered by the Federal Arbitration Act. They leave open the possibility that she will be covered under state law. But interestingly, I decided since I was doing this panel, I'd look up Illinois state law. So Illinois state arbitration law would probably enforce this arbitration agreement, but there's actually a section which says that they exempt any claims that fail to comply with the terms of the Workplace Transparency Act. So I thought, oh, what's the Workplace Transparency Act? Well, it turns out the Workplace Transparency Act in Illinois says any agreement, blah, 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 that requires an employee to arbitrate is unenforceable. I'm summarizing that. But I actually think in Illinois, it seems as though it's not likely she would be bound to arbitrate, even though she has an arbitration agreement, because Illinois has this Workplace Transparency Act. But we'll see if I have correctly interpreted this. What's sad about this case is it is so narrow. Sure, we now know ramp supervisors and anyone loading and unloading cargo are going to be exempt from the Federal Arbitration Act. But what do we really care about? The gig workers, the Uber and Lyft drivers, the Amazon last mile drivers. There's tons and tons of people who are all arguably engaging in interstate commerce. And are they going to be covered by this exemption or not? Here's my prediction, they're not. So I think the Amazon last mile driver, that's the driver who picks up the goods at the Amazon warehouse and delivers them to your house, drives the last mile. My view would be this Supreme Court seems to be emphasizing the narrowness of the exemption and wouldn't include those folks under the transportation worker exemption. The Uber and Lyft drivers, it's a little trickier. I think if you're in Ohio, like I am, and you live in Columbus in the center of the state, I'd be hard pressed to see an Uber or Lyft driver as someone who's transporting goods in interstate commerce. But what about if you live in New York City and you're driving back and forth to Connecticut? And Uber drivers don't just take people; they take things. They deliver food and whatever else they deliver. And I guess I think there's at least a stronger argument if someone's routinely crossing state borders, maybe they could fit themselves within this exemption. But I almost wonder if that'll be a case by case basis decision. So ultimately, this is kind of a frustrating decision because it doesn't really address the issues that one would have hoped it would, but they were able to reach consensus on it. So in that way, it's, I guess, a positive.
Yeah, thank you so much. Absolutely great insights. I think it is interesting. There's going to be a lot more cases that come up because it is so narrow and leaves a lot of open questions for the future. So we're going to move to Angela again, and we're going to talk about a case that came out just a few days after the Southwest Airlines case. It's the ZF Automotive US Inc. versus Luxshare Limited. It was decided on June 13th. So Angela, take it away, please.
Yeah, and I thought I should talk about this case since it did come out on my birthday. But this case is really interesting. And what is, again, it's another unanimous decision, 9-0, but we're hearing a new voice here. This is the first opinion from Amy Coney Barrett. This is her first arbitration decision since she joined the Supreme Court in 2020. And I really, let's actually, before I'm getting ahead of myself because I'm getting excited about this case, but let me go through the facts. Let's talk about them first. So ZF Automotive, it's a private commercial contract with ZF Automotive. German's parent required, and it had a requirement that disputes be arbitrated before the German Arbitration Institute. Now, that is an arbitration provider that is focused for those folks in Germany. The case, however, was brought in Detroit before the commencement of the German private international arbitration. The issue is focused on discovery. The U.S. District Court allowed requested discovery on appeal to the Sixth Circuit. ZF Automotive, in a very unusual move, petitioned for certiorari before judgment to bypass waiting for the Sixth Circuit to decide its appeal. The Sixth Circuit declined to stay with the lower court's order, and the respondent Luxshare requested and was granted discovery for arbitration. So in that discovery, they alleged fraud against ZF Automotive under Section 1782. The Supreme Court then granted certiorari on December 10th and then reversed the lower court decision today. So that's kind of where we were with this case. But one of the things that I found fascinating, that if, in Justice Barrett's focus on the opinion, she really focused on something quite finite and small. And that was the phrase foreign or international tribunal. That is really the crux of her analysis and argument. She actually cites Black's Law Dictionary. So I said, my goodness, you can't get any more basic than citing Black's Law. And what she really looks at in her analysis is that if we look at the phrase foreign or international tribunal, which is specific to Section 1782, that reads, the district court of a district in which a person resides or is found may order him to give his testimony or statement, or to produce a document or other thing for use in a proceeding in a foreign or international tribunal, including criminal investigations conducted before formal accusation. So that she relies on those 4 words, foreign or international tribunal, and then uses that to ensure that this company has to provide discovery. And we know that international companies, this company in particular, would want to rely on district court discovery because the discovery that they would be requesting would be more robust. They would be able to get more than they would want in another situation. And so it's fascinating because not only did Justice Coney Barrett rely on just those 4 little words, but in essence, the case was decided on dicta. And we know that this isn't the first time that the court has made arbitration law based on dicta. They've done it in several cases in the past, but really, I think if we look at where the court is going with this narrow interpretation, I think because they're not looking at things with such broad strokes, that it's really going to change the tenor and tone of how arbitration is interpreted for other companies. And so what this case is really saying is that only a governmental or intergovernmental adjudicative body constitutes a foreign international tribunal. And what that means is that this will open up what can be used for discovery, and that states can actually go and use a district court and have better access to discovery. And if you think about it, if you're a foreign company and you're wanting to do business, you're going to take into consideration where you're going to actually go if the case is going to go to trial. And you want a jurisdiction that is going to be most beneficial to you and to what you're going to be bringing to the table. So I think this is a fascinating look. And it's also a fascinating kind of getting back to basics. And I love the way Justice Coney Barrett really used those 4 words and really brought it back to basics with this.
Thank you. Yeah, I mean, it'll be very interesting to see, especially with international arbitration, what kind of a difference it makes. Certainly, it kind of snuck in there with all of those there are 3 cases in June. I mean, June was a busy time for SCOTUS on arbitration, so it kind of snuck in there, but it really does have lasting implications, especially in the world of international arbitration for sure. Because just a few days later, on June 15th, we had yet another decision. And this one actually did get quite a buzz because of it having to do with the Private Attorney General Act and some really sort of interesting questions about preemption. And I know you're very passionate about this one, Imre, because we had talked about it before it was even decided. And so I'm sure you're going to have fun covering this. So take it away, Imre. Viking River Cruises. Again, June 15th, another 8-1 decision.
Thanks. Just real quickly on the prior case, I disagree a lot with these cases, but I really think if you took a textual approach, the word tribunal, I am confident with this, it meant arbitration back in the 1920s. And for us in America, the seat of arbitration, it can have an impact, but it's not as significant as with international arbitration. The seat means a big deal. And so when I saw foreign tribunal, I immediately thought, okay, this could cover an arbitration proceeding seated outside of the US. And so I disagreed with the result in the ZF opinion as well. But looking at Viking River, from older Supreme Court cases, and I'm talking about like American Express and Concepcion, we know that if you have a class action waiver and an individual promise to arbitrate, that class action waiver can be fully enforceable. State law cannot impose class procedures on an arbitration. Having class procedures impose an arbitration is viewed as inconsistent with the notion of simplified arbitration under the FAA, according to an older line of Supreme Court authority. But what about representative proceedings, like the proceedings allowed by California's PAGA or Private Attorneys General Act, where one worker can stand up in the name of the state, acting as a proxy or an agent of the state, and collect penalties for an employer's violations of the state's labor code, even if violations have to do with other coworkers. And I love Star Wars. And so I think of the PAGA statute. It's sort of like a bounty hunter statute or Boba Fett. And so I call this the Star Wars or the Boba Fett statute. And for me, this case, it can be understood as part of a larger debate about individual actions on the one hand, as opposed to group or collective or representative actions on the other. Can a worker be forced to assert his or her individual claim alone in arbitration, or can the worker speak out on behalf of a larger class of other coworkers through a representative action? And so I tend to think of this case as David versus Goliath. Are you going to be just bringing your claim alone as David, or can David, who signed an arbitration agreement, seek to recover penalties on behalf of all other coworkers who work for the same employer? And part of Justice Alito's majority decision here conceptualizes PAGA as involving a mass free-form joinder. And I think part of the problem is, how do we think of PAGA to begin with? And one view of PAGA, it's just the joinder rule. That's one view. And according to Justice Alito's majority opinion, a worker can be compelled to arbitrate one-on-one his or her individual claims pursuant to an arbitration agreement. And state law like PAGA cannot be used to impose an arbitration a broad, free-form joinder of claims involving other parties. And so that part of the decision is very consistent with older cases like Concepcion, American Express, and Stolt-Nielsen. And this is a very splintered opinion. Justice Barrett, joined by Justices Kavanaugh and Chief Justice Roberts, wrote a separate opinion narrowly agreeing that state law cannot be used to impose this free-form joinder in arbitration. Complex joinder or aggregation is viewed as inconsistent with a fundamental attribute of arbitration. And as a result, Ms. Moriana, the individual in this case, the worker in this case, has to submit her individual claims to an arbitrator. So she'll arbitrate her individual claims one-on-one. But what about the representative claims? Ms. Moriana was also suing on behalf of just state labor code violations with respect to other coworkers at her workplace. And she was suing really on behalf of the state as a proxy for the state. And the majority characterizes PAGA as involving also representative claims where a worker is suing as a proxy or an agent for the state. Now, this part of Justice Alito's decision, in my opinion, is not well reasoned. It's not well explained. It's not well developed. But the court very quickly says that California's Iskanian rule with respect to the representative claims, they're still valid and they're not preempted by the FAA. And so these representative claims could remain in court as long as there was proper standing for a worker to pursue these claims. And just Ms. Moriana's individual claims can be sent to arbitration under her arbitration agreement. And again, I think the majority decision does not explain this well. I think it's underdeveloped, but I believe that there's an older case called Waffle House that provides support here, even though Viking River doesn't cite Waffle House at all. In Waffle House, you have the EEOC brought an enforcement action against an employer. And the Supreme Court held that the EEOC, a government body, was simply not a party to the arbitration clause between the worker and the employer. And similarly here, with this Viking River case, the representative claims under PAGA, they're viewed as belonging to the state, with the worker serving as a proxy or an agent of the state. And so these claims can remain in court, just like in Waffle House. And I wish the court would have cited Waffle House here, but they didn't. And so I think Justice Alito could have provided more reasoning, but it talked more about state sovereignty to enforce its own state laws. But this is, I think it's not reasoned well, but he recognizes that the representative claims can remain in court as long as there was standing. And Justice Alito goes on just to give his opinion about California law, and I think he crossed the line here. He says that according to an older California Supreme Court case called Kim, a worker does not have standing to bring representative claims unless the worker's individual claims are also pending in court. And so because Ms. Moriana's claims, individual claims, were kicked out of court, the representative claims should also be dismissed. And Justice Alito cites a 2020 California case called Kim for this proposition. And I hate to say this, but I don't think Justice Alito actually read Kim, because I think Kim supports the exact opposite result. In Kim, the worker had settled his individual claim, and the California Supreme Court allowed him to proceed with representative claims in court. And so I think Kim actually stands for the exact opposite of what Justice Alito cites it for. Under Kim, under this California precedent, Ms. Moriana would have standing to proceed in court with the representative claims. And Justice Sotomayor criticized Alito for, she acknowledges that Alito could be wrong, and it's really up to California courts or the California legislature to share what California law is about or what California law holds. It was incorrect for Justice Alito just to opine what he thought California law was. And so there's a recent, there was a petition filed last month for rehearing by Ms. Moriana, where she's asking the court to reconsider this last part of the majority opinion dealing with California law, that the court should not have addressed this. Instead, this should be addressed more appropriately before the California Supreme Court or the California legislature. So there's currently a pending petition for rehearing in the Viking River case. And the California Supreme Court in July, just 2 weeks ago, accepted a case involving Uber, where they will address this exact issue. Can an individual worker pursue representative claims even though they don't have any individual claims under PAGA? And so hopefully this last part of the Justice Alito's opinion, where I think he made a misstatement about California law, hopefully it'll be clarified soon. Sarah?
I just want to ask Imre, what do you think is going to happen with that? It was really interesting. I talked to the Bloomberg reporter, Robert Iafla, who, if any of you like to read about arbitration, he's extremely knowledgeable. And he actually noted to me that he thought that was a mistake. And I just wonder what you think, Imre. I feel like California is likely to figure out some way to allow an employee to do this because it's kind of an anti-arbitration state. But
well, I think California is going to just reaffirm Kim and recognize that workers can bring representative claims, even if they have no individual claim. And this is my wish list, but I'm hoping that other states will follow that PAGA as a blueprint to adopt similar PAGA statutes elsewhere. So there's a nice window of opportunity created by this Viking River case, recognizing there's a possibility of representative claims that they could, without, it's not well reasoned, but they leave open this window for representative claims to remain in court. And so I think just California has to close that loop and clarify it. And I think hopefully other states will begin adopting that.
I have to agree with you on that, Imre. I mean, I agree there is an opportunity. And I think it's important for, these representative claims to have voice and not be cut off. And there's definitely merit, and there's definitely an importance in the ability to bring these representative claims and not have them shackled to an individual claim that may or may not go forward. So I think that's very important.
Any other thoughts on certainly the Waffle House point is, I put the case link in the chat in case anybody wanted to check that out. But I do think it raises some interesting questions, sort of in light of this most recent opinion. So yeah. Any other thoughts, anyone, on any of the cases before I move to sort of questions and start facilitating discussion for our final 35 minutes?
I was going to make a comment about Badgerow because I was reading a recent Sixth Circuit decision, which I was going to later when we're talking about cases that we think may create issues down the road. But interestingly, it's a case involving a collective bargaining agreement And the Sixth Circuit has to go through what I think we'll call the Badgerow analysis, indicating that the Labor Management Relations Act is the source of jurisdiction for reviewing an arbitrator's decision on a grievance, but says, like Imre pointed out, properly understood the arbitrator's award as a contractual resolution of the party's dispute, and then says, well, refusal to comply with the labor arbitration award is itself a contract violation, which the Labor Management Relations Act grants jurisdiction over. So they say it's a contractual right or contractual violation, and therefore triggers their federal court review. But wow, it just seems really tortured to try and find that federal jurisdiction, and makes me wonder how often it's going to be the case that a federal court actually takes jurisdiction over a motion to confirm or vacate. I was just like, wow, this is a mess, and maybe it's going to be difficult for courts down the road.
So in light of, sort of all 5 cases and looking at them sort of holistically, I mean, there are some sort of interesting elements. We talk a lot about, well, we're abiding by quote unquote the text, but not in a historical manner, right? As Imre pointed out. And so there's some sort of questions that kind of like a tortured textualism, or what sort of a textualism do we think this is? I wonder if you had any thoughts on that question first, before I move to sort of to Colin's question.
Yeah, I just have an observation. Like 10 years ago, I used to think for any arbitration case, like if we were to bet on it, Sarah, I love your suggestion. I think Colin mentioned we have like a fantasy league on arbitrate.com. I would love that. But if I had to bet 10 years ago on an arbitration case, arbitration always wins. Today, I think my answer is different. It's if we already have prior precedent, likely it'll be followed under stare decisis, but any new issues, it's got to start and end with the text. And so I definitely see a different approach. But I think even with the textualist approach we saw with the ZF automotive case, I disagree with it. Even the textual approach that we saw with Badgerow, I just don't think the statute was ever designed with that mindset of a textual analysis. And so it's the FAA is so, and we're approaching the 100th anniversary, and it's so in need of amendment.
Oh, well, that's just,
yeah.
I not agree more. And we do have, we do have a new act, the Enforced Arbitration Act, which I was going to comment on when we talk about the future cases. But, I agree with you. Arbitration always wins, but I still feel like it sort of is, or that, that we're trying to keep Saxon is all about keeping all the workers in arbitration, even though, in my view, workers were never intended to be included in the scope of the Federal Arbitration Act. And yet, once more, they very narrowly interpret this, and it just made me feel like, boy, the Lyft driver, the Uber driver, the Amazon driver is gonna lose too, and be bound by their arbitration agreements. But I hear what you're saying. There's sort of these minor victories. I feel like the waiver victory is such a minor victory. And I don't know enough about international arbitration to know how big of a decision that was. But I still feel like arbitration wins, which I don't necessarily think is always a bad thing. I just feel like that's still what's happening.
Yeah, I mean, definitely these cases have really spotlighted arbitration as something that's here to stay. It's not something that the court looked to really tear down or reframe in any way, shape, or form. But I do have to agree with you, Sarah. I think for some, for the little guy, I think that there's still that worry that there's not that protection there. And then perhaps they are going to be bulldozed because there is an arbitration agreement in every single contract that they sign. So I don't know that that's necessarily going to be addressed by the court, but I think it's definitely something that's kind of worrisome after effect of arbitration for the little guy.
Yeah, I mean, I think it's really an important, going back to Imre's point, I have to agree, it used to be, well, arbitration wins no matter what, but now I really think it's important for counsel to think about doing their homework and making sure that they understand what the text says and looking at the cases in their jurisdiction in a way that maybe wasn't quite as strong as it is after this term. Which kind of brings me to the next question that Colin also added in the chat, and I think is the big, $22 million question that we all want to ask, right? Is so Colin says his main question is what all these cases indicate about where SCOTUS may be going on arbitration over the next 2 or 3 terms. If we were to sort of read the tea leaves, what do you guys think?
Well,
Who wants to be first? Sarah, please. Yeah.
And Imre probably wants to add in on this. I know we've talked about the enforced arbitration of sexual harassment and sexual assault acts in a different forum. I mean, actually it was on arbitrate.com, I think, too. But at any rate, that one of the big issues in that statute, which exempts sexual assault and sexual harassment claims from pre-dispute arbitration agreements, in other words, they're not enforceable for those types of claims, was the use of the word case rather than the use of the word claim in the statute. So the statute says no pre-dispute arbitration agreement shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute. And one of the great points Imre made in a past panel was to say, well, what if you have, a race claim, a sex claim, and a wage and hour claim? Are you going to split those up? Because the use of the word case rather than the use of the word claim creates an ambiguity with respect to what claims should actually be going to arbitration versus the entirety of the case. And there's sort of at least 2 potential, or 3, I think you had, Imre, potential interpretations of this. But I think that's what we're going to see cases related to that interpretation. And I think under the sort of textualism principle, the court will say, well, you don't have to arbitrate your sexual harassment and sexual assault claims, but you do have to arbitrate your wage and hour claims and your race claims until Congress says differently about those types of claims, because I think they'll say that's what you agreed to, and our job is to enforce arbitration agreements. There's always an asterisk there that what if these are very intertwined claims? I can see an issue then, and maybe all the claims go to court at that point, but I think this is going to be something we see going forward as an important issue, something that unfortunately Congress could have clarified but failed to do so.
Yeah, I think that statute will definitely bring some new litigation. Other things we see, tea leaves. Anyone want to read their crystal ball? Imre, go for it.
Yeah, I think it's just going to Colin's question, where is the Supreme Court heading? And I think my answer to that also helps explain, I think, why we have such an unprecedented number of cases this past term. Why were there 5 this term? I think where's the Supreme Court headed? Something that surprises me every time I think about it is if you look at the AAA, the American Arbitration Association, they have this nice little ticker at the top of their website of how many cases they've resolved to date in this particular year. I haven't checked in about a month, but I think they still have that. And if you look at their numbers of how many cases are resolved by the AAA, it rivals the filings of the entire federal judiciary in civil cases. And so for me, I think all the justices realize the power and the value of arbitration to help alleviate, an overburdened judiciary and caseload in the courts. And so I think there's never been so much talk in Congress and society in problems with arbitration. I think arbitration has had a bad rap over the last few years. And of course, we have the most recent amendment involving sexual harassment claims, sexual assault claims. My view is that the Supreme Court may be concerned, unless they clean up arbitration law, will there be more, far-reaching amendments to arbitration? And so I think that they are trying to clean up and fine-tune arbitration, make sure that it's working very well. And I have a feeling, and for me, there are a lot of still existing circuit splits and lower court divisions on interpreting the FAA with very, very fine points. Like I think even Badgerow creates problems. Angela and I are working on an Airbnb case this month involving delegation clauses and clear and unmistakable standard. There's so many little fine points of arbitration law that have to be clarified. And I think the Supreme Court is trying to clarify them to get ahead of the legislative curve. And I think that if arbitration is viewed as unworkable, I think there'll be even greater calls for reform. And so that's how I explain the 5 cases this term, that there's such a push and interest in reforming arbitration law like today, like never before. And to help preserve our system, the courts tried to clean up these fine points.
And if I can, I guess, shine my crystal ball as well, where I do see, the Supremes really embracing and really looking at arbitration. I think the concern is that a lot of their interpretation has been very narrowly focused. And so I think, while Imre is saying that, yeah, they're trying to go and to kind of fine tune and clarify some things, I think that they have been really narrow in their interpretation of really what arbitration is and who it's going to affect. I think one of the great victories that victim survivors did have was the forced arbitration clause of sexual assault. That was something that was a wonderful victory for sexual assault victims. But then you kind of look at that kind of juxtaposed with some of the other cases, and there's not an alignment there. So I think that there's still a lot of work to do. If Imre's prediction is correct and that the Supremes are trying to get things aligned to get ahead of what's coming down the legislative pike.
Yeah, I mean, there's these, small little circuit splits, as Imre said, that have big implications. I've been actually keeping my eye on Section 7 and its application for online arbitration, because there's a split there in authority. And what are they going to do about technology? I think we're going to see more questions that certainly were not on the minds when they were putting together the FAA in 1925. So, it's a brave new world, but the implications, looking at, from January to August of 2022, you're looking at 372,794 cases. It's here to stay, and arbitration can be tremendously beneficial in so many different areas. I'm curious as well. This wasn't even, on our list of questions, but, another thing that has come to my attention as well is under the Federal Arbitration Act, it doesn't really, we don't see family arbitration in the United States, but other countries are seeing a rise in family arbitration. I wonder if that could come up. I mean, I think about new areas for arbitration that we might not have really thought about under the FAA per se, but it'll be interesting to see if reforms come online. Any other comments or thoughts? And how about from the audience? If anybody would like to chime in with some thoughts.
I think Sarah had a comment first, and then.
Oh,
and then
great.
let's go to the
Okay,
audience.
please. I didn't see that.
I was going to say that with more and more cases going to arbitration, I think you're right, Amy, that there are going to be difficult interpretive questions about which there is very little guidance. And what you need to tee those up is somebody who's disgruntled about the arbitrator's ruling. But I know, because I've done Zoom arbitration, that a big issue is granting subpoenas for witnesses who are in a different jurisdiction. And I had a case that the arbitrators were sitting, two of them in Ohio and one was in Tennessee, and the witness who we wanted to testify was in Illinois. And we signed the subpoena to have that person testify, and they did come, but they weren't controlled by either party. They could easily have said this is well outside the arbitrator's jurisdiction, and the FAA just doesn't address that. The FAA just says arbitrators may summon in writing any person to attend before them as a witness and to bring papers. Well, we didn't want to be there. Well, we did want to be there for the testimony, but if you sign a subpoena for a deposition of a witness who's outside your jurisdiction, I don't have any interest in sitting there while some lawyer takes the deposition of a potential witness. People could say, the witness could say, or the party could say, we're not going to allow that. We're going to go to court. I don't know what the answer is to that because the FAA doesn't address it. And so I just think there's going to be more and more questions as basically lawyers treat arbitration as private litigation. And I thought it was funny reading about Morgan versus Sundance, that one of the objections to having to stay in litigation and then go to arbitration is that discovery might be broader in litigation than it is in arbitration. And I'm sure that's generally true, but the arbitrations I've been involved in, the lawyers treat it just like litigation and want the same amount of discovery and haven't limited discovery in their commercial agreements. And so you end up with these I assume very similar discovery processes in arbitration that you'd see in court. So really not much difference.
And how about, thank you for that comment. Absolutely. And anyone in the audience have some question? Neil, did you want to ask? I see you have something in the chat.
Yes. Hi, everyone. So I was wondering about the criticism that the Supreme Court is facing because of some of its decisions in a number of cases. And the fact that they adopted a sort of textualist or narrow approach in interpreting the arbitration provisions in a number of these decisions. I was wondering if the criticism that they have faced because of these decisions, as well as overall on as a reason, or rather due to the decision in other key issues like abortion, will they have a slightly different approach in any future arbitration cases that come up before the court? Especially if we look at the decision in Southwest, I believe that the Supreme Court, because it took such a narrow view, there are still a number of cases that can come up regarding the other gig workers, Uber, Lyft, or Domino's. And in these future disputes, if the Supreme Court does take up the case again, will it prefer to have a slightly broader interpretative approach, or will it look at taking a different approach? Because there has been so much criticism in terms of a textualist approach to interpretation.
I would say, setting aside some of the major cases like Concepcion, that the Supreme Court often takes a much narrower view or tries to decide things very narrowly in arbitration cases. I've often been really frustrated with the decisions of the Supreme Court that could have addressed a lot of issues. And I often say to myself, I wonder why they either took this case or decided only to narrowly decide this case. And I don't know, I guess I think this is a court that doesn't seem to be bothered by criticism. I mean, I don't think whatever criticism they're going to take on arbitration front's really going to keep them awake at night if decisions like Dobbs and others, don't. No one's going to protest outside their house for an arbitration decision. I guess I see them as continually doing this narrowly, and it's just not very helpful. Like you're right, Neil, I think that if they had decided Saxon more broadly and given some, even in dicta, guidance as to what is and isn't a transportation worker, that would have been very helpful. But they chose instead to just decide the case in front of them, basically, and leave us all wondering what happens to all the Amazon and Lyft and Uber folks.
Yeah, but don't you see that? I mean, that's kind of what they did with the majority of the cases that they reviewed. They only dealt with the case in front of them. I don't know that they were looking broadly enough to really look at things that might be coming down the line. And I think that they're going to continue with this. And I know Sarah and Imran, you've said that it was, it was a narrow interpretation of these cases. And it's something that I think they're going to continue to do.
Agreed.
And I agree with you, Sarah. I don't believe that they're bothered by that. I think they only want to deal with what's right in front of them.
I guess aren't they the Supreme Court? So they should actually decide things that are, they're providing guidance. I guess they're saying, well, every analysis I read of any of these cases said, here are all the questions that the parties raised that the Supreme Court did not decide. So and I know, Imre, you've talked about that on your blog about some of the things that weren't addressed that should have been or could have been.
Yeah, I share these frustrations. I think these decisions are so narrow. Sundance, Badgerow, they leave open so many, and undecided, so many other issues. And I just to follow up on Neil's point or question, I do see, maybe I'm reading too much into this, but I do see possibly an impact of Dobbs on the Viking River decision. I thought it was just so strange that the Viking River decision does not cite Waffle House. I wish the court would have characterized a Private Attorney General's Act as state action. And that would be, if they applied Waffle House in Viking River, I think that would be the result. They would be characterizing and conceptualizing PAGA statutes as state action. And I think with in the abortion debate, we saw the Texas statute that was framed at, the Texas statute was designed also as a private bounty hunter statute. And I'm seeing more and more discussion of private bounty hunter statutes around the country to deal with controversial issues. And I think the court is hesitant to come out and characterize bounty hunter statutes as state action. It's just a way to evade, I think, a challenge to bounty hunter statutes. And so I do see, I may be reading too much into this, but I do see how other potential areas of law are just further constricting arbitration decisions. But I think in general, the arbitration decisions are very narrowly decided.
I mean, I do have to say, I picture some clerk had to have asked them about Waffle House. Like, I can't imagine that nobody even considered it. Do you have any take on that, Imre?
Yeah.
I mean, I just think it's bizarre that they didn't address it.
Yeah, it was brought up in several briefs in Viking.
Yeah.
So I just thought it was strange that, and it was the least developed part of the opinion. And I just think I think it's a spillover about what happened with Dobbs. And it just, Private Attorney Generals Act are being considered at local levels to deal with all types of controversial issues, like the teaching of critical race theory in schools. Like you could, I forget which district, but a parent can sue a school board or a school for teaching controversial topics with a Private Attorney Generals Act. And there's an argument, I don't buy it, but there's an argument, this is not state action, so the First Amendment doesn't apply. I would say this still is state action, and I would have loved to see Waffle House applied in these contexts, but it was left out in Viking River.
Other questions from the audience? Any other, I guess another big, important sort of final question in our final 10 minutes is, really for practitioners listening or who are on the call. What are the takeaways that you would want to be sure that as an arbitration practitioner that you really take into account and consider in the wake of these decisions?
I have
Go ahead, Imre.
one narrow comment about Southwest, and it's I think Sarah mentioned this earlier. Like, if you fall under the transportation worker exemption, the next logical step is let's look at state law, right, to see if state law fills in the gap. And I found 2 district court decisions where the federal court refused to look at state law because the agreement said that the arbitration clause said that this arbitration clause shall be governed by the FAA. And so the court said, no, we're not looking at any exemptions. The FAA does not apply. This case is remaining in court. And so I would be very careful in drafting arbitration clauses. That will have an impact, I think, with the transportation worker exemption. And also in Viking River, and this is also another drafting issue. Viking River had a severability clause. Like, if any part of the arbitration clause is struck down, is invalid, the rest of the clause is fully enforceable. But I've noticed a lot of arbitration clauses have what I call a poison pill or a blow up clause, where if any part of the clause is struck down as invalid, the whole arbitration clause blows up. And so if you're in California now, representative waivers are illegal, they're invalid. And if you have a blow up clause in your arbitration agreement, and you have an invalid waiver of representative claims, which is, I think, invalid now under Viking River, the whole arbitration agreement blows up. And so I would be very careful with drafting what law governs the arbitration clause, and I'd be very careful in how I draft any blow up. I think it's worthwhile to revisit arbitration clauses today, especially in light of the amendment involving sexual harassment claims and in light of the decisions from this term.
I'd second that as well. And I think that we've been emphasizing drafting arbitration agreements for many years, but really it doesn't seem like there's been that dramatic a change in the way parties approach their arbitration agreements. And I know I spoke to corporate counsel one time and they said, look, we just don't have time to negotiate the dispute resolution clauses in our contracts. We're looking at how much this thing costs and when the deal is going to get done. And they sort of leave that issue for another day and never get to it. And so I think you're right, Imre. And I think that, in terms of the waiver case, this idea that you better be sure that you bring up your arbitration agreement pretty early in the process, or you may find yourself not able to enforce it later on. And I did just want to note, it's a little off topic, it's on arbitration, but the Sixth Circuit case where I found this Badgerow analysis, I was reading it with interest because the Sixth Circuit said an arbitrator has power to bind a non-signatory to an arbitration agreement if there is clear and unmistakable evidence that the non-signatory wanted to participate in the arbitration. And I thought, what? There's no, this non-signatory didn't sign the arbitration agreement, and it was a grievance involving an employer who was owned by another entity, and it was the other entity who claimed that they said, we didn't sign this arbitration agreement, we shouldn't have to go do anything in arbitration. And at the arbitration said, we don't agree that we're bound by this arbitration. And the arbitrator went ahead and bound them anyway. And now the question is, the district court has to go back and make findings as to whether it was clear and unmistakable. And I don't know I get where the clear and unmistakable language is coming from. We've seen that very frequently in arbitration, but I always thought it was sort of inviolate that unless you have some contract principle that you can apply that will bind a non-signatory like estoppel or a third-party beneficiary or something along those lines. Now we're just going to have like, you didn't protest enough about it and therefore you're now bound. That struck me as weird and something that I thought down the road we'll probably see at the Supreme Court.
Yeah, as a contracts professor, I just cringe. Angela, did you have any final thoughts?
Just I think if the Shine case, is one to keep in mind as we talk about the importance of drafting. Just ensuring that documents are up to par, that they have language that can that folks understand, I think is just of critical importance. I'm going to keep it short and sweet on that one, but just drafting.
Yeah. Well, of course, I do love that as a contracts person.
Definitely.
Yeah, right. But the problem is, at the time of contracting, nobody pays any attention to the arbitration provision. It's usually sort of just thrown in and usually not negotiated, but it should be. I think it's an important practice pointer. I always emphasize that in class as well, that I think it's, something that's often overlooked, but truly important.
That's where the problems lie.
Yeah.
That's where they arise because we don't pay attention. It's an afterthought. And then we've got to come back and we've got to reinterpret and try to figure out. And that's why we had the issue in Shine. So that's, drafting.
Yep.
Very important.
I did an arbitration recently where a doctor had sold his practice to a company, and so there was a sale of the company, but he continued to work for the company afterwards, and this is a pretty common thing for a professional to do. His employment agreement had one arbitration agreement that had a lot of different provisions and an attorney's fee award if there was a prevailing party at arbitration, but the deal to sell the business had a very different arbitration agreement. And you're basically saying to the arbitrators, figure it out. So you're leaving to the arbitrators, and the arbitrators probably I wasn't too excited to try and figure this out myself. It was really hard. How do I decide which arbitration agreement prevails? It would have been a lot easier if the parties had understood that these arbitration clauses were different, and they were in a great position to do that, but didn't.
This has been tremendously, really some great food for thought. Wonderful job giving an overview on all of the cases from the term and the takeaways. I know I really appreciated this discussion, and I'm really thankful on this August day for you taking this time to discuss these cases. Really great, really interesting stuff. So thank you. Thank you to everyone. Thank you to the panelists. Thank you to everyone who attended. And as promised, it is being recorded and will be posted on arbitrate.com, and also we will post it, I hope, somewhere on Ohio State's website as well. And any other final thoughts, or shall we let you all enjoy the rest of your afternoon?
Thanks, Amy and Colin. Really
thank you so much, everyone. The video will be up by this evening, and we'll share it with all the registrants. Thank you to the panelists, and thank you, Amy, for facilitating the conversation.